comes to dispute resolution, unfortunately, everything is still a black box. Why should dispute resolution continue to function the way it did multiple decades ago? And that is today the mental burden that we carry whenever, as citizens, we get stuck in dispute scenario. We are integrating AI. What does that mean? As a user, as someone who comes to us with a complaint, you can, instead of maybe asking a case manager what the next date is or what should you be doing at this stage of dispute, you enter it as a question in the chatbot that we provide to you. And that chatbot may be providing you with curated content as per my rules. The easier, the quicker you're able to resolve your conflicts and disputes, the better it is for the society.
I will go to our question from Shmel. Shmel, would you like to ask your question?
Yeah, I want to ask a question. A very interesting presentation. I too very interested in the topic of resolution conflicts. And I want to ask you a question. How online resolution conflicts can support improvement social and mental well-being?
So asked how resolving conflicts can help social and mental well-being. Am I right?
Yeah, this question.
How resolving conflicts online can help social and mental well-being.
I think it's a response to that question will be obvious for anyone who has gone through the rigor of resolving disputes through courts. And that is the sort of comparison that I tried to draw in the initial portion of my conversation here. But we can actually, I think, draw an analogy from other aspects of our life, right, Mr. Shmul? The way we are today interacting with any other kind of service provider. We identify going to a physical store and picking anything that we want as an exception in our lives today. We think carrying cash around in its physical form is something, again, we do only in very dire circumstances. You know, the other side will not have you interacting with them online or through technological means. That is when you resort to the older ways of doing and thinking. So when everything else is moving at the pace that it is, especially in the AI age where everything is at the click of a button, knowledge is no longer a barrier, for instance. All the answers are at your fingertips. With respect to any aspect of worldly knowledge, universal knowledge, everything is something that you can access from the comfort of your home. But when it comes to dispute resolution, unfortunately, everything is still a black box. And this used to be all right in an India of 1970s, 1980s, where every other aspect of life was also equally stuck. You know, we were dependent on one channel, we were dependent on one source of information, we were heavily dependent on the government to give us those services, amenities in other aspects of life. So dispute resolution, seeking justice was also one such aspect of life. So it did not feel as burdensome. But today, when every other angle of my life is something as seamless, and there are so many choices that I can make, and I want to, immediately get redressal when something is not to my liking, why should dispute resolution continue to function the way it did multiple decades ago? And that is today the mental burden that we carry whenever, as citizens, we get stuck in dispute scenario. So therefore, when we provide here an avenue for even this part of life to become digital, for even this part of life to be handled online, and most importantly, for this part to also have transparency and choice, the kind of neutral who will get to decide your dispute. I think the choice aspect is the most important, which gives a sense of comfort to any individual. So I would firmly believe that in terms of ability to reduce mental stress, online dispute resolution is a perfect avenue to resolve most categories of disputes in society today. And as I was mentioning, the upliftment of society is closely tied to whether everyone is following the rules. If there is breakdown of rules, if there is breakdown of rule of law society, as we call it, then there is chaos everywhere. So the easier, the quicker you're able to resolve your conflicts and disputes, the better it is for the society.
Also, Shmel, when issues are not dealt by the judiciary, tribes form in societies. Tribes based on religion, tribes based on caste, tribes are based on communities. And they nourish antisocial elements. And the first people they will use is the underprivileged. The underprivileged gets sucked into a vicious cycle. Getting the judiciary system functioning, cutting down the average time for a dispute resolution, weaning out corruption, can bring in a safer and more stable society where everybody, even the underprivileged, get equal opportunity to grow. I don't know if I'm articulate enough, Deepika.
That makes perfect sense.
Yeah, yeah.
Thank you very much. And I want to ask another short question. I want to ask you how, according to your opinion, generative AI technologies like ChatGPT, Gemini can support online resolution conflicts.
Absolutely. The way we are developing code, today we have an end-to-end platform, which, as I mentioned, helps you with ingestion of documents, the scheduling, all of that. The multiple aspects of dispute resolution life cycle is seamlessly handled on one platform. And at every layer now, we are integrating AI. What does that mean? As a user, as someone who comes to us with a complaint, you can, instead of maybe asking a case manager what the next date is or what should you be doing at this stage of dispute, you enter it as a question in the chatbot that we provide to you. And that chatbot will be providing you with curated content as per my rules, because the biggest risk with generative AI and generic solutions out there is that it won't have the context of your dispute and it won't have the context of my rules. My institutional rules is what will be guiding the entire process. But with AI integrated into my own platform, you will be assured of a right answer, an answer with very high scoring in terms of confidence levels in the answer itself. That is how today the answers are evaluated from various LLMs. But when it is something that the institution itself provides, the confidence score is usually 99 to 100%. So yes, we are integrating AI at every layer because that is what is the present. It is not even the future, right? And the way we are able to come up with creative and customized solutions for different dispute categories. For instance, the kind of process that I'm curating for RWA disputes, that is Resident Welfare Association disputes, is going to be very different from what it is going to be for my shareholders or founders level disputes. Earlier, maybe even a month or so ago, the investment of time that I as an institution would have to make, the investment of money that I would have had to make to come up with customized workflows would have been very high. But today I'm able to do it in the matter of days. So the kind of experience you will have with us will also be very seamless and something that will speak to you. And that is the whole advantage that AI today is giving. But I would advise people against relying on generic LLMs to seek answers to their dispute scenario. Maybe they upload a general question and get a very fundamental sense of what their next steps should be, but I wouldn't rely on it to give me a final answer, which in any case will not be binding. That is the whole purpose of resolution. So to some extent, knowledge creation, awareness building can be done through LLMs at your end. But when it comes to resolution, going to institutions should be your final step.
Thank you very much.
You had said that there are different types of disputes: property, tenancy, workplace employment, marital family matters, consumer grievances, schools and colleges, contractual disputes. So you've listed that out. Have you a list which says, in the current state in India, what is the percentage of these disputes?
When it comes to what we see entering the judiciary, ironically, tenancy disputes form a huge chunk.
Is there any statistics exactly of what percentage is what? What are the number of cases?
I myself do not have those numbers at the tip of my fingers, but there are now very credible sources like the National Judicial Data Grid that you can go to, where the data from each and every court is aggregated and presented across different dispute categories. So you can go through that to figure out what is taking up a huge percentage of, when we say 5 crore cases pending, what is that comprised of and at what level. So district judiciary, as I said, has the maximum number of cases. And even within that, we see tenancy disputes being one of the major clogger. On the criminal side of things, even though we say, again, crores of disputes pending, there it is Section 138 cases that take up a lot of time. So what becomes evident here is most of these disputes are of the nature that can be resolved outside of courts, but are clogging up the court system, which means that the judiciary does not have the bandwidth to deal with slightly more complex cases, which is what its main role ought to be.
Excellent. As you said, that to remove clogging of the judicial system, we in India need alternative solutions. What is happening in Delhi to resolve this?
Specifically in Delhi?
Because the central government is there, the legal ministry is there.
Yeah, that's a very good question, Shivani, because when we talk about trust building in the alternatives, right, I think anyone who follows what the highest levels within the government are speaking and doing, and highest levels even within the judiciary are speaking and doing, is to push cases towards these alternatives. Even this CJs of India, all the CJs over the last decade and a bit at least, in almost every other speech of theirs, they highlight the need for parties to embrace arbitration, embrace mediation. Those are the headlines of today, because the institution understands that they are overburdened, unfortunately, by those disputes that should ideally belong to private institutions, or in private contexts, parties are able to resolve them directly. So when it comes to the government as well, thankfully, there is unified support that especially through legislations like the Arbitration and Conciliation Act and the Mediation Act, which came out in 2023, there is unanimous support for parties to embrace mediation, embrace arbitration. My only push would be to embrace it through an institution, because as I said, providing for only arbitration and mediation is not enough in a dispute scenario, because you need processes, you need guardrails, you need to know who will be appointed, and that is the kind of comfort, and I don't know, it is almost like it is the streamlining of the whole process that an institution guarantees.
So the Mediation Act has come in 2023, but it is not mandatory. Anybody who has a conflict can ask the other person, please come for mediation. But the other person has a right to decline it.
Absolutely. Absolutely. So both with arbitration and mediation, the key element is that of consensus and party autonomy. So the parties have to agree to have their dispute resolved through arbitration, and that needs to be a very categorical agreement. Because what that means is you are removing the authority vested in courts, and the courts have default authority over all disputes. But you are making a conscious choice that no, I want it to be resolved through mediation and arbitration. So there is a very high threshold that has been set for courts to acknowledge and identify that yes, this is the option that the parties have opted into. So it is not an opt-out, it is an opt-in mechanism. However, there are exceptions. As I said, Commercial Courts Act mandates pre-litigation mediation. The results are not something that we are all proud of, but still there is mandatory mediation that the parties have to attempt before going to court. And that is something that is going to increasingly get introduced in other categories of disputes as well, including, say, consumer disputes, where now directly people go to court. The default in the near future will be mediation first, and only if it fails, then arbitration. But the thing is, Shivani, as I keep saying, it is heavily dependent on the party's willingness to resolve, especially in mediation. The parties should want to settle. But the culture today in Indian society is, I will fight it out. That needs to change. And that is a mental framework that mental shift needs to happen. And that is where you and I, we have to work hard to create awareness and increase the knowledge about benefits of mediation.
So it's not that people don't want to settle with mediation. It is because the oppressor, the offender, knows he can get away with the judiciary system in the courts by dragging this case for another 20 to 30 years.
Yeah.
Not knowing what the results is, he uses it as a tool to blackmail the defender.
That's right. You're absolutely right. 100%. So the effectiveness of mediation is actually getting significantly reduced due to the state of the courts. Courts are seen as, again, places where things can be gamified. You can have perverse incentives at play in courts, which you rightly said becomes a tool in the hands of parties who have not come into the process with good faith.
The CGI is highlighting the need to move towards mediation arbitration is the first step, most needed, excellent thought process. Now, the second step is to make the mediation act functional, to make arbitration functional.
Yeah.
What is that? As you said, as you already said, just like Commercial Courts Act is mandating pre-litigation mediation, all the different types of categories, everything can do that, can do the same pre-litigation mediation or arbitration or RERA is a fantastic thought process. Now, at a time when the business world is able to, the corporate world is able to find solutions to huge problems. Finding solutions to our judiciary is not a big deal. Finding solutions to to speeden up the 5 crore case is not a big deal in today's world. The thing is, for example, today, arbitration is a fantastic thought process. You can resolve an issue in 15 days, but corruption seeps in. Today, even so-called judiciary judges who have been noted for their integrity for 60 years of their life or 70 years of their life in the fag end of their careers are making arbitration a farce. So you said that for the common man to identify an arbitrator, that there is a panel available. Can you please explain that?
Right. So one of the issues with the way arbitration is currently administered, especially when it comes to court annexed arbitration centers or even in ad hoc arbitration mechanisms where the parties have not identified who the arbitrator should be, there is something called a Section 11 petition, which when you file in the High Court, invariably the arbitrator who gets appointed is a retired judge. And we all more or less understand what the drawbacks of something like that can be. Of course, in a complex dispute where you want someone to hold that sort of authority with the parties, where you want that level of understanding, having someone with that kind of prestige, backing, reputation, expertise is absolutely critical. So I don't have anything per se against the retired Supreme Court and High Court judges, but they may not be the right fit for all kinds of cases, right? And that unfortunately has become the default when it comes to Section 11 petitions, which is why it doesn't make sense for all kinds of disputes. The way we are trying to solve for that at CORD is to have a very wide ranging panel of arbitrators and mediators who come with very diverse backgrounds. Some of them are in fact retired district judges. District judges have a much better understanding of the integrity of the processes, and they are used to handling cases at with a shorter duration in comparison and contrast to what the Supreme Court judges and High Court judges are used to. So we do have retired district court judges on our panel, but we also have lawyers with different areas of expertise, and they bring in that expertise to resolve disputes. We have retired bankers, retired ombudsmen who we have trained with the principles of mediation and arbitration, trained on how to have the processes outlined depending on the kind of dispute they are handling. For instance, again, going back to RWA, because that is one of the favorite categories of dispute that we handle here at CORD. A huge game changer, because especially in Bangalore, you may have heard of, huge apartments having everything from, noise to pets to blocking of common areas. All of that becomes a nagging issue on a day-to-day basis. For this, you don't need a retired judge. You need someone who has basic common sense and can understand the process, and that process includes giving an opportunity to hear from both sides, recording the minutes of that proceeding in a transparent manner, and giving that avenue for seamless settlement, mutual settlement between the parties. So they are trained on principles of arbitration, principles of mediation. So that is the kind of vetted panel that we have. Some of them come to us with prior dispute resolution experience. There are a few others who come to us who we then upskill to become neutrals.
Okay, so COD, is it a quasi-government organization? Is it?
We are a private organization. We are a private limited company. And that was the reason why I had that slide, whether ODR is legal, whether court administered disputes have legal binding. Courts have upheld awards, settlement agreements that have come out of court. Most of the ADR institutions are private limited companies. And as long as institutional rules are in adherence to the Arbitration Act, Mediation Act, and any other laws that are applicable in this ecosystem, our institution can take on cases. It is as good as, I don't know, you may have heard of SIAC, Singapore International Arbitration Center, or MCIA, Mumbai Center for International Arbitration, DIAC. These are all brick and mortar institutions that people are maybe familiar with already. We are a pure digital first approach institution. We are 6 years old.
So you said they're different. Now, the second question is, one is the RWA which you're dealing with. There is also the family disputes, whether it is between husband and wife, whether it is about women issues, whether it is about property issues. Are there anything like COD which specialize in these?
I think most of the institutions today, Shrivani, are generic institutions. Of course, we have come to have specialization very organically in certain categories of disputes. But we are, through our rules, in a position to handle any civil dispute that is arbitrable or mediable as per the statutes. We can take those. There are, to my mind, at least no dedicated ODR institutions to deal with just these categories.
Are there people in India who are doing research for policy changes on these issues to ameliorate the burden that the common man faces in any of these types of cases?
There are quite a few think tanks that are focused on access to justice. They work on the policy side of things. They work directly with the judiciary and other government departments that are relevant. Then there are others who work directly with people who are in need of assistance, right? People who, as lawyers or as paralegals, work with parties who need assistance in filing a case in court, so on and so forth. So there are a wide variety of institutions, Shrivani. In terms of policy itself, the place I worked at previously, Whitley Center for Legal Policy, is one of the leading think tanks that champions the cause of improving laws, improving processes in ensuring that the last mile, which is access to justice, is actually delivered to the citizens. And that was my area of work for nearly 7-8 years.
Yeah. Now, the second question I have is on arbitration. When arbitrators turn corrupt and the big builders have the money to handle it, whereas the small tenant holders or the building holders, they don't have the wherewithal to read the contracts they have signed. They don't have the money to fight such big builders. Since you come from the RWA issues, what is the solution for these small owners?
That is a slightly complicated issue, Shrivani. There is no straight answer for corruption angle in the society, right? With our rules, at least, what we enable and empower the parties to do is challenge the arbitrator appointment at any stage of arbitration, which is also the reason why I keep stressing that you want to have an institutional arbitration as opposed to ad hoc. When it is ad hoc and you bring in a retired judge, it becomes that much more difficult to question whatever it is that they may be doing. It may be simple things like not sticking to timelines which also is a big thing if you ask me, but to something which gives a sense of corruption being involved. But if you have an institution, we are in a position to pull the judges up, and we give you an avenue to challenge the appointment, and we can help with replacement of the arbitrator at any stage.
Yeah.
So that is one of the remedies that will be available with parties, but they can do this at the stage of contract signing. Post that, it becomes difficult, which is why even if they don't read anything beyond the bare minimum commercials, all the other clauses are something that they don't want to pay attention to. At least pay attention to dispute resolution clause and push for including ODR, especially for small time home buyers. They cannot keep going to court all the time, right? Have online dispute resolution as one of the options available. Ensure that there is an institution that is identified. All of this is a way for you to mitigate the hurdles, the burden that you will face when in a dispute scenario.
And CORD has a panel of arbitrators.
That's right.
And this is available. CORD is available only in Delhi or across the country?
So, as an institution itself, we can take disputes from across the world. We also handle cross-border disputes. We are registered here in Bangalore, but given the nature of our offering, which is online, we can handle disputes across the country.
Okay. Now, arbitrations, the rule is that it should be completed within a year. Why do they go on for 10 years?
It's the same as what you see in courts, and it is the creature of who the arbitrator is, what are the guardrails. Again, I think for most of your questions, the answer will be institutional arbitration. Ad hoc, which is where, you just appoint an arbitrator and leave them to run the show. And they do that typically, very old arbitrators with their personal secretary who is trying to coordinate between the parties. That takes its own sweet time, and it mirrors what happens in court. But with an institutional arbitration, it becomes very professionally run. I'm in fact currently dealing with a case where the parties are asking for adjournment after adjournment. In fact, the arbitrator is pushing for adherence to original timelines, but the parties are seeking adjournments.
Both
So
sides.
as an institution, I'm stepping in because I have the power to do that under my rules. I'm stepping in and saying, if within these timelines, the next milestone is not achieved, which is submission of documents, then there will be additional costs imposed. So there needs to be a very solid stick. You have to have a carrot and stick policy, and our rules provide for sufficient leeway for us to step in as an institution when parties or the arbitrator are not sticking to the process outline.
So what is the rule which says that it should be only for 1 hour?
1 year.
1 year. Then what happens?
So if within a year the finality is not achieved, even the arbitration legislation provides that the parties can extend it in concurrence with the arbitrator. So they keep extending unless one of them goes and challenges any inefficiency in court. The role that an institution again plays is to really check if it is suitable in that particular case for as much extensions of time. Sometimes there may be a very legitimate reason why extension of time may be necessary. Maybe some documents are stuck in some other courts, or there is some genuine difficulty in adhering to the processes. There will be some dependencies somewhere. And in that situation, we cannot be cutthroat in the way that, if it goes beyond 1 year, then the process gets stalled there. And that is not the approach we take either. The ultimate end goal we are all pursuing is resolution, but resolution that gives satisfaction to all the parties involved. Nobody should feel that they have been robbed of an opportunity to present their case. So that is extremely important. So that is what happens when there is breach of timelines. You really have to take it case by case.
So 1 year goes away, 6 months goes away, then you go to court. Court takes 5 years, and then they say you have to go back to arbitration again because the contract has arbitration.
Yeah.
The purpose of pushing for alternatives to the judiciary, like arbitration or mediation, is because any dispute can be resolved in 15-20 days.
Absolutely. And that, Shrivani, is the creature of pendency in courts, right? When there are 5 crore cases pending, your case is one of the many, and you have to join the queue. Each judge is hearing at least 100 different disputes every day. And the timeline for each dispute, it keeps getting added on. Your case is not getting any personalized attention. If you're lucky, then your lawyer is at least giving you some personalized attention and is strategizing your case. With an institution like court, each case gets its own case manager, and we ensure that the arbitrator who gets appointed discloses upfront what their availability is. And the case procedural timeline is decided in the very first hearing. In the first hearing, you have complete view on when your case will end, what will be the milestones across each stage in the life cycle of a dispute. So this is the kind of service element that you get when you come to an institution, unlike what happens in court. In court, you're one of several.
Now, one party might approach court. The other party has appointed ad hoc.
No, that doesn't happen, because in a contract is where you decide how you will be resolving disputes when they do arise. And the contract is something that both of you sign together. You will not have two separate dispute resolution clauses.
No, the dispute resolution clause says, I will put my arbitrator, you put your arbitrator,
not how it
deciding
works.
arbitrator.
No. In the dispute resolution clause, what you can do is, as I said, one simple line. Dispute will be resolved through arbitration. That gives rise to complication when the dispute arises. So that is something you should avoid. What you can also do is say, when a dispute arises, this will be the arbitrator. So you very specifically name who the person is going to be. Or if the dispute you expect to arise out of it is slightly complicated, very high value, then you say, I will appoint one arbitrator who is so and so, you will appoint one arbitrator who is so and so, and these two persons will then appoint the third neutral arbitrator. And this is something you have to agree at the time of signing the contract. At the time of signing, it can't be that I will choose one arbitrator and the other party is going to be silent on it. That is not how it works.
So we choose one, they choose one.
And they have to
they will put a presiding. Now, my point is, the first one, the defender is choosing one arbitrator from, like court, an institutional arbitrator. The offender can still choose an ad hoc arbitrator.
Ad hoc I don't get the authority unless you have mentioned me in the clause.
The contract says, the contract has said, one side will appoint one arbitrator, the other side will appoint one arbitrator.
You have to name the arbitrator. That is the ideal scenario.
Contracts don't say that you need to. Because
that is the ideal scenario. Otherwise, you'll be stuck in a situation like this.
But then, not everybody, this contract signing will happen 1 year later, dispute will happen 5 years later, the actual resolution will happen 10 years later.
Which is why the awareness is important.
So it is not possible to actually put the arbitrator's name at that point. Doesn't make sense.
A lot of cases, in fact, when it comes to ad hoc is non-institutional. Ad hoc doesn't mean the arbitrator is somebody who hasn't been named. So there is ad hoc arbitration clause where the arbitrator is mentioned by name. And most of the clauses today, contracts today fall into this category, where there is some pre-decided gentleman, some experienced woman who is identified as an arbitrator. But again, there you are leaving it to chance that that person is someone who adheres to timelines, who can be pulled up if something goes wrong. So the parties take up a lot of burden on themselves when there is no institution mentioned. But the right thing to do is, as much as possible, reduce ambiguity when a dispute situation arises. So you have to preempt what those complications can be and address that at the time of contract drafting.
Assuming it's not done.
Then you are unfortunately stuck in a situation where you have to go to court to get your arbitrator appointed under Section 11.
No, assuming, let's not keep the Section 11 for the future. Assuming the contract does not have the arbitrator's name put. One of them chooses court, an institutionalized arbitrator fixing. The other person can always say, no, I will put my own arbitrator, right?
In fact, the person who wants to come to court also cannot come to us, because I won't take up a case until I have the authority from both the parties. That is a pre-requirement for me. So you are left in a situation where you have to appoint an individual arbitrator on your own. I will not give you my arbitrator. What I can do is, on your behalf, I will invite the other side to consent to my authority. So if I'm not originally there in the contract, what I'll do is that party A has approached me for court administered arbitration. Do you consent to this? If party B consents, then we proceed with the arbitration.
Got it. So now another question I have is, videos are being taken in the Supreme Court for all the cases, right? Does that happen in the district courts, high courts, single bench courts, in the arbitrations and mediations?
Arbitrations and mediations, no, unless confidentiality is guaranteed, because that is one of the main requirements, right? That is also where our platform becomes important. Videos are stored in a secure, confidential manner. In district courts, live streaming and video recording hasn't become the norm yet. But in Supreme Court and in a few high courts, live streaming and recording is permitted and is regularly put to use. That is possible there because they are courts of record, right? Everything is ought to be in public domain, but not in arbitration and mediation.
What is the last question about the family courts? Are there anything like COD which actually keeps privacy and close settlement issues quickly?
So with the family courts, there are court and mediation centers attached to every family court. That is one ready avenue that is available. But where the parties want, they can come to private institutions like ours. Again, there they will have to agree to this. Both the parties have to agree to come to court. And once they do, we appoint mediator from our panel.
All right. Done. Thank you so much.
Thank
It was a very enlightening talk on a very important topic. India is one of the most beautiful country today, with UPI. We've gone way ahead of the world. I wish that people like you and COD would really bring a revolution in the judiciary system. Thank you so much.
Thank you, Srivan. Thanks, everyone.